Okay, let's talk about the petition to remove conditions on residence. That's when you file the form I-751. Basically, you were married and you got a conditional green card through marriage, and now you want to remove that condition. And remember that most people only know that they can remove it with the husband jointly, but sometimes you can remove it on your own if you meet certain requirements. We will focus on that as well. Okay, let's get right into it. What is the purpose of this form? Basically, this petition is used by a conditional resident who obtains status through marriage. Okay, this is only for people who obtain their green card, their conditional green card, of course, through marriage. And then they want to request that the USCIS remove the conditions on their residence. Okay, that's why you use this form. So who's qualified? Who may file the form I-751? If you were granted residence status to marriage to a U.S. citizen or a lawful permanent resident, you're going to use this form and to remove those conditions. And if you have dependent children who acquire conditional residence status on the same day as you or within 90 days after you acquire that conditional residence, then you can include them, their names and alien number of those children in part 5. Remember, when we talk about children, those are children under the age of 21, of course. Okay, and then you file the form to request that their status, the condition on their status, be removed as well. So basically, you can file it for your kids as well using the same form. If those dependent acquire that conditional residence status on the same day as you or within 90 days after you acquire that conditional residence status. But if your dependent, your children who did not acquire conditional residence status on the same day as you or 90 days after, so they can do it. Or if the conditional resident parent is deceased, like your children, you are you're not here, but you are deceased, somebody, the kids want to file, they can file by their own separately. So each child who will use their own form I-751 separately to have their condition removed. Okay, so that's how you apply for this form. That's who's qualified. So let's say you are still married, then you can file it jointly with your spouse to whom you obtain conditional status. However, you might file, that's where we're going to really focus, you might file it on your own without your spouse if you entered the marriage in good faith, but your spouse died. You got married to a U.S. citizen, and then your spouse died, and you are still married, like now you become a widow. So basically, you can file on your own, okay? And then, but you have to prove that the marriage was entered in good faith, and this, we already talked about marriage entered into good faith. You can please refer to my previous videos because we have talked about it a lot, and you can just refer to it to know whether the marriage was entered in good faith or not. And the second is that you enter the marriage in good faith, but the marriage was later terminated due to a divorce or annulment. So you can, let's say you got married to a U.S. citizen or a lawful permanent resident, you can also, and then you got a divorce later on, you can also file on your own to remove those conditions, provided that you can show that your marriage was entered into a good faith, but you just got a divorce. So you enter the marriage in good faith, but you have been battered or subject to extreme cruelty by your petitioning spouse. We have explained about subject to being extreme cruelty and battered spouses in VAWA. So we have explained about it. You can refer to VAWA videos to know what they mean by battered or subject to extreme cruelty. But anyway, let's say you have been battered and you have been subject to extreme cruelty and you have that 2 years conditional green card that you want to remove the condition, but your spouse is not cooperating. You can file on your own, provided that you prove this. And the first part, of course, marriage in good faith. So you can also file on your own. The marriage was entered in good faith, but you have been battered or subject to extreme cruelty by your parent, your citizen or lawful permanent resident spouse, or by your conditional resident parent, or the termination of your status and removal from the United States will result in extreme hardship. Oh, let me explain this a little bit more. Remember that you have been married, okay, to a U.S. citizen or lawful permanent resident, and now you want to remove that condition. You got granted a 2 years green card, but now you want to remove that condition so that you can get a permanent green card. But now the spouse doesn't want to collaborate and file with you jointly. But as long as you can prove that the marriage was entered into good faith, then you have been subject to extreme cruelty by the parent of a U.S. citizen or lawful permanent resident, or the spouse, or by your current conditional resident parent. So you can, as long as you show on top of it too, not on top of this one, but as long as you can show extreme hardship, if they remove you from the United States, you can file this form on your own. So basically, extreme hardship, we've talked about it when we talked about VAWA. In order for you to really show extreme hardship, you have to have a qualifying relative and show that your removal will create extreme hardship. Okay, so but in this case we can even argue that the extreme hardship is just about you, even if let's say the qualifying relative is not really sufficient to show extreme hardship on their behalf, but then we can just argue on your own behalf that removal will result in extreme hardship. Okay, so if you're filing jointly, this is the condition. When should you file? Now, if you're filing jointly with your spouse, there's no problem, but you must file during the 90-day period immediately before your conditional residence expires. If you're filing with your spouse 90 days prior to the expiration of your conditional residence, that's when you file, 90 days. But if you're filing that joint filing requirement be waived, and then you wanted to file on your own, remember we talked about how is it possible for you to file on your own, then you might file this form without your spouse if they are deceased, you are divorced, or your conditional resident child were battered or subject to extreme cruelty. You might file this petition at any time after you are granted conditional resident status and before you are removed from the United States. So in conclusion, if you're filing on your own, you can file it at any time after you have granted conditional residence status and before you get removed from the United States. So you must file it when you are still here. But remember, if you're filing on your own, then you have to meet the previous condition that we talked about. Either you have been subject to extreme cruelty, either you have been divorced, or either the spouse died, or it's going to result in extreme hardship, stuff like that. So in order for you to qualify to file on your own, So we talked about it previously. But now they're talking about if you don't file, if the petition is not filed, you will lose your permanent resident automatically. You will lose that status for 2 years from the date in which you were granted conditional status. So you will then become removable from the United States. So if you don't file it, automatically you lose it. And then you become removable. So really, either way, you still have to file. Okay. And then some people, not to confuse with VAWA, because with VAWA, really, you don't, most people with VAWA file before they get the conditional green card because they haven't even gotten that one yet. So that's when they file, or they never even apply because the spouse has become so abusive he doesn't even want to apply. Okay, for them. So not to confuse that. But anyway, if you don't file, this is what's going to happen. You lose it and you become removable. So this is a special note. If your failure to file was through no fault of your own, you might file your petition late with a written explanation and request that USCIS excuse the late filing. But you have to have a valid reason, okay? So, but you have to demonstrate that the delay was due to extraordinary circumstances beyond your control, and the length of the delay was reasonable. When they talk about extraordinary circumstances beyond your control, they're talking about something that happened that you couldn't control. That's why you couldn't file. For example, somebody got sick, so sick that they got hospitalized, and you were focusing on taking care of them that you couldn't file. Something beyond your control, and you have to explain it, prove it, and then show that the delay was reasonable. The length of delay was reasonable. Okay, that's kind of high standard if you're filing late. So, and then we have general instructions, pretty much how to file it. And then we have required document. What type of required documents? Okay, it says what initial evidence is required. You have to show the permanent resident card, and then exception, they say those who reside overseas pursuant to military or government orders, including conditional resident dependent residing overseas, must submit the following item with form. So those who are outside of the US, they have to have 2 passport style photos and 2 completed fingerprint cards, form FD 258. Okay, and then you have to show evidence to the relationship, birth certificate of children born in the time of marriage, if you have any lease agreement or contract. Okay, financial record, joint ownership, and that's how you show good faith marriage with those documents, because remember, you have to prove good faith marriage first before now you start removing the condition. So that's how it works. Okay, affidavits are sworn or to affirm by at least 2 people who have known both of you since your conditional residence was granted, and they have personal knowledge of your marriage and relationship. So those are the things that you have to submit with in order to prove good faith marriage. If you're filing as an individual due to the death of the spouse, submit a copy of the death certificate with your petition along with evidence of the qualifying relationship. So the death certificate and the other evidence such as marriage certificate and all that. If you're filing because the marriage has been terminated, you have to show the copy of a final divorce decree or other documents showing terminating or annulling the marriage. So if you're filing because if you're filing as an individual because you and or your conditional resident child were battered or subject to extreme cruelty, then you have to submit evidence of abuse, such as copies of report or official record issued by the police, medical personnel. So basically the way you prove VAWA, the same thing. So if you claim you were subject to extreme cruelty, that's when you can show like mental abuse, physical abuse, all that proof. If you went to a shelter, you can show it. If you talk to a medical professional, proof of it, anything that shows that. A copy of decree if your marriage was terminated by divorce on a ground of physical abuse, extreme cruelty, then you add a copy of your divorce decree. So pretty much that's it. Those are the things that you have to file with in order for this removal of conditions to be successful. And then here they talk about criminal history. So if you have criminal history, you have to prove it too, to show. And then we have filing fees. Of course, they have filing fees, $595, and then you have biometric, $885. So if you're eligible for a waiver so that you don't have to file because of income requirement, you can file with the form I-912 to request a waiver so that they can waive those fees as well, especially for someone who's claiming extreme cruelty. That waiver will work because they're having difficulty with the money because they're going through a lot. So this waiver can work for them. Okay. And so I think that's it. So it says, if you knowingly or willingly, falsely or conceal a material fact and or submit false document, okay, they will deny that, and they may terminate other immigration benefits, and you will face severe penalty provided by law and may be subject to criminal prosecution. So you need to avoid sending false documents because this is gonna get into marriage fraud, and that's not good because then you will become inadmissible. So that's it. Really, I wanted to just talk to you about the form I-751 because a lot of people get confused thinking that they really just have to file with their spouse to remove that condition. But really, if you fit those 4 or one of those 5, then you can file on your own, but still you have to have a way to prove it. The first thing, you prove good faith marriage, and then you prove the second thing that is required. So go ahead and read those parts from 1 to 5, and then look at the documentation that are required, and read this part as well. Then if you have additional questions, you can call my office or email me. But the moment you call my office and email me, just know that consultation fee applies, and we'll be able to help you remove that condition. Okay, Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead, subscribe, share, like, comment below. I always answer those comments the best of my ability. But if you really need a case assessment and you're serious about your case, you should consider a consultation, and you should consider paying for consultation as well. That's when we'll take the time to research your case and advise you properly on your case. Okay, thank you again. Until next time, bye bye.